right, the time is 8:31. This is the special March session of the Municipal Court for the town of Breckenridge. I'm Judge Ron Carlson presiding, and we are court record and we are recorded. Court will call matter set for motions hearing. Court will call the Anderson case. I have the appearances of those who are here.
Robert Gregory on behalf of the town of Breckenridge, attorney registration number 42560.
Under special appearance, I am the man, which is the sole beneficiary, and the secured party and the authorized representative for the CQV trust in which you just announced appointing yourself as the trustee for, Your Honor.
You're Christopher Anderson.
I'm sorry, today for this matter, Your Honor, I believe that you being the trustee are Christopher Anderson.
No, sir, you are Christopher Anderson.
Sorry, Your Honor, I think whoever announced the case is the name of the trust. Me, I'm a living man.
Sir, you are a person under the United States Constitution.
No, sir, I am not a person as defined by Black's Law Dictionary. I am a living man.
No, you are a person under the United States Constitution, and Black's Law Dictionary is not authoritative as to that regard.
No, sir, I am not a person.
Sir, rule number one person speaks at a time, and you don't interrupt.
I'm sorry, who are you? In this matter, who are you?
I am the judge presiding over this matter.
So you are the trustee, the public trustee for this matter.
I am the judge presiding over this matter. Your characterizations are not recognized by law. So,
Okay.
we will proceed accordingly.
Do you have a valid oath of office, sir?
I did. I was duly appointed by the Town Council of Breckenridge at a public session, and I am a judge in the state of Colorado in a number of jurisdictions besides this one.
So, I'm sorry, for the record, one time, you do have a valid signed oath of office pursuant to Colorado Revised Statutes 24-12-101?
Yes.
Okay. For and on the record, this court takes judicial notice of the judge's sworn oath.
Okay, we're going to proceed with the matter set for today.
I'm sorry, can I ask a question, Your Honor?
You may.
Is this matter about substance or form?
This is about the pleadings you filed with this court.
So, substance or form, sir?
It is both.
Can you please elaborate?
No, it's about the subject matter of which you brought motions, and that involves both substance and form based on my reading of the pleadings. Record will reflect that I have received the pleadings in this matter, that I have read them all, and will proceed accordingly.
So you accept the appointment of being the trustee for this matter?
I am the judge for this matter.
The trustee, the public fiduciary trustee.
We've been over this, and we're not going to beat a dead horse here.
Okay,
You
so
have your position.
then I presume.
My position is, I am the judge presiding over this matter, and we're going to move on from here.
Okay, so
I've heard enough of this.
I'm presuming with witnesses here today on record that you are the trustee for this matter, and the town attorney, Mr. Robert Gregory, is the executor who initiated these charges and allegations.
You may characterize it how you wish, but that's not characterizations of the law of the United States and the state of Colorado and of the town of Breckenridge.
It is under the United States trust
stated your
law.
position. Sir, once I've ruled, that is the end of this discussion.
I do not accept or consent to your rule, and I do not accept your offer.
Well, I understand that you're advocating a sovereign citizen position.
I'm sorry, sir, there's no such thing as a sovereign citizen.
Well,
You're either sovereign or you are a citizen, and I am not a U.S. citizen.
Oh, but you are.
No, I am not.
I understand you deny that.
I actually am not a U.S. citizen. I am an American national.
I understand your character.
I have declared my status, and I am not a resident of any political party within the state of Colorado or any state thereof. I do not recognize your authority under the United States Constitution. I only recognize my republic form of government under the United States of America, in which constitutes the law of one and common law. That is only under the supreme law of the land, which you swore an oath to, which we have on record already that you took that this court takes judicial notice of your sworn oath of office in front of witnesses here today and God.
I understand that is your position. All right, moving on. You have filed with this court a number of motions. The first motion is motion to demand court read all pleadings filed with this court and adhere to constitutional compliant law, more particularly the Bill of Rights and its rulings. The people, Mr. Gregory, has responded, having no objection to the court having read the pleadings.
I'm sorry, sir.
Do not interrupt me, sir. That I've read Mr. Gregory's response, which is he has no objection to the court reading the pleadings. The court has done so accordingly. So I consider this motion disposed of, that it is granted in part as far as the reading of the pleadings. Any extraneous part, there is no wherefore paragraph asking specific relief in this motion. There is a citation of a number of cases and not a wherefore, so that I consider this motion granted in part and disposed of. Next, the court has a motion to dismiss with prejudice. Mr. Anderson, do you have anything you wish to add to what you filed with the court?
So my name is not Mr. Anderson. I do not consent to you calling me that. I am not the corporate fiction which you have created and which you are the trustee of. Secondly, pursuant to the 6th Amendment of the Constitution of the United States, I have the right to face my accuser, so I would like the accuser to step forward as the living man so that I may face my accuser. For this court to not allow that would be a dishonor of the court.
Well, the right to face your accuser has to do with a trial about the substantive accusations that I believe include disorderly of the peace, and we're not here to address that today. We're here to address the motions you filed with the court. If you don't want to have those motions heard, I will consider that you have defaulted and forfeited your position on these motions.
I'm sorry. So here's the maxim of law as far as all my motions that have been filed with the court, to include all of the affidavits. Both the court and the prosecuting town attorney, which is the executor for this trust, have failed to properly rebut line for line. So those are automatically default granted. So this motions hearing in which you're attempting to coerce under threat and under duress is a moot point, because you have no authority to order or rule any other way other than granted, as the fact of the matter is the prosecuting town attorney failed to, within the 21-day time period, to rebut and address any one of the motions or the matters.
I understand that's your position. Mr. Gregory, is there anything you wish to add to what you filed with the court?
Your Honor, so as the court noted, the people did respond to the motion to dismiss for subsequent response. The people relied on the responses and the assertions stated in the people's motion. And don't have anything further, and do not feel that any witnesses are necessary. These motions that were filed by Mr. Anderson were they are essentially constitutional and jurisdictional in nature, and generally, as the court can see, it's the people's position that this court has subject matter jurisdiction over Mr. Anderson. The court has personal jurisdiction over Mr. Anderson. The court has substantive jurisdiction over this matter, and personal jurisdiction over Mr. Anderson in spite of his assertions otherwise. And the defendant's references to being sovereign or a natural citizen do not defeat the court's jurisdiction and should not be recognized by this court. So we ask the court to deny the motion to dismiss, and I'll withhold any other their statements, I guess, with respect to the third motion that people responded to, which was the response to the notice to the court. But that's our position with respect to the motion to dismiss. We asked the court to deny it.
And I've requested that they bring forth the jurisdiction and show subject matter and also personal jurisdiction of the matter, which they have failed to do. That was during the first hearing under the last judge that recused himself for not having a valid oath of office. The second thing is too that the town attorney, Mr. Robert N. Gregory, attorney registration number 42560, does not have a valid signed oath of office pursuant to Colorado Revised Statutes 24-12-101. He stated that for and on the record during the last hearing, along with Judge Buck Allen, who also does not have a valid signed oath of office. And they did state that they took an oath with the Bar Association, which is a private members association, and that has no standing in law. So the court should not recognize the town attorney as even having any standing in this matter because he does not have a valid signed oath of office pursuant to state law and also federal law. I've also filed with the Summit County Sheriff's Department, who holds jurisdiction over this court because it is a municipal court located within the limits of the Summit County. And the sheriff of Summit County holds the authority for that because he does not have an oath in which all judicial officers and fiduciary trustees of all matters are required by state law to have a valid signed oath of office. So I would like the court to take jurisdictional notice of Colorado Revised Statute 24-12-101, which outlines exactly what the oath of office for all officers that are operating within the state of Colorado and Colorado State are required by law, in which you, sir, after having taken your oath of office, which you state you do have a valid signed oath of office, which I'm waiting for the Secretary of State to return your oath of office so that I can verify that. This matter needs to be dismissed because the prosecuting town attorney, number one, cannot be an injured party, nor can the entire state or the people of the state of Colorado, because that would be an oxymoron, as I am one of the people of the state of Colorado, and I cannot bring any criminal matter against myself pursuant to the Fifth Amendment of the Constitution of the United States. So anything that the town attorney has to say on this matter is moot and void on its face for not having a valid oath of office.
I understand your statement of position. The motion to dismiss is predicated upon supremacy clause, citations under that. It lays out 7 elements of jurisdiction which are not applicable in this matter. The court takes judicial notice by the fact that Mr. Gregory has an attorney registration number that is not with the State Bar of Colorado. That is, in fact, with the Supreme Court of the state of Colorado, is where attorney registrations are conducted in the state. So Mr. Gregory is a licensed attorney qualified to practice law in the state of Colorado in all of its courts, including this one. Court does recognize that subject matter jurisdiction is established under Horton versus Southers, 43 Pacific 3rd, 611, and Colorado Supreme Court case from 2002. In addition, Colorado Revised Statutes 18-1-201 establishes that this court, this municipal court, has jurisdiction within its geographical boundary within the state of Colorado. Colorado Constitution authorized in section 20, and it's Roman numeral 20, it's article Roman numeral 20, section 6, as well as Colorado Revised Statute 13-2-104, as interpreted Hardeman versus Municipal Court in the city of Boulder, a 497 Pacific 2nd, page 1000, 1972 case, indicates this court does have subject matter jurisdiction over the ordinances passed by that municipality. Court further notes that this court specifically, as sitting judge, that the municipal judge of any municipal court has all judicial powers relating to the operation of court, subject to the rules of procedure governing the operation and conduct of the municipal court, subject to those promulgated by the Colorado Supreme Court under C.R.S. 13-10-112, subparagraph 1. The defendant is accused of violating Town of Breckenridge Code, disorderly conduct, assault, and open containers, all of which are ordinance violations if proven at trial. The court does have subject matter jurisdiction. The court finally finds that the court has personal jurisdiction over the defendant and that he has appeared in this court. He was also personally served with a summons in this matter, and jurisdiction is acquired when a person is arrested or served with a summons and complaint under C.R.S. 16-3-105. See Weld County Court versus Richards, 812 Pacific 2nd 650, a Colorado Supreme Court case from 1991. The circumstances the defendant is bringing up are not relevant to and are immaterial to personal jurisdiction of the court under Sweeney versus District Court, 713 Pacific 2nd 914, a Colorado Supreme Court case from 1986. There's been some reference to national, citizen, and sovereign. While the defendant rejects the characterization, are commonly referred to as part of the sovereign citizens movement in the legal literature. And the 10th Circuit has rejected that concept as far as the federal courts. In Charlotte versus Hanson, a 433 Fed page 660, and cert denied U.S. Supreme Court. The court finds that the court does have both subject matter and personal jurisdiction in this matter. The motion to dismiss with prejudice would have to have been predicated on something along the lines of lack of probable cause, or that there's no facts upon which the case can be based. And the court does not find that applicable, so the court will deny the motion to dismiss with prejudice. The next is not a motion, but a notice to the court, objection of non-statutory law, writ of quo warranto proceeding, challenging jurisdiction of the court to issue an order in support of violation of due process, is how it is styled.
I'm sorry, Your Honor. I need to clarify something real quick for the record as part of the due process. So you're denying the motion to dismiss, which should follow all other motions, because all other motions were put in prior to that motion to dismiss. Also, the right and writ of contract. So pursuant to federal law, all law, the person must have an offer, an acceptance, and the condition of that offer, and which can be rescinded. I have sent in properly a rescission to the summons in which the court has alleged that I had received proper notification of in the motion that you just denied. So that would deny me proper due process of law by automatically going to a denial of the dismissal following or before you go through any other motion. So I do not consent or accept your offer to deny that last one until you've gone through every single one of those motions. And then you can read through and see that you have no subject matter or personal jurisdiction over any part of this case. Secondly, I'd like to make note and on the record that this court is in a dishonored status you are in violation of Title IV, Chapter 1 of the United States Flag Law, which specifically states that the United States flag must be displayed when at the vertical position on the flag's own right and the observer's left. As I look at you from where I'm standing on the observing point, the flag is on the wrong side, making this court in dishonor.
Okay, court, as far as the defendant's statement understands that's his position, we'll note that contract law does not apply in a municipal court prosecution for ordinance violations, and jurisdiction, personal jurisdiction cannot be revoked on contract principles when the defendant is in fact present in the court.
I'm sorry, I'm here for special appearance, not general appearance. I established that before we even started the proceedings. So the defendant is not here. The defendant does not exist except for on paper, which would be this paper right here. This is a birth certificate.
I understand that's your position.
That's not just my position, that's what the law states under trust law, which you are violating and creating a constructive fraud onto trust
And
law.
I understand you are sticking by your position on trust law, and the court does not accept your position. Again, to the notice regarding quo warranto, is there anything you wish to add in that regard to that, Mr. Anderson?
That motion needs to be before the motion that you just dismissed on the motion to dismiss this.
And then I will entertain the motion to dismiss with prejudice, since you indicate this should be determined first. Let's discuss it.
So
Do you have anything you wish to add to what you've pled?
the facts are within that the fact of the matter is that I've already established it on record again when I stated on record for this hearing today, which I also add to that, or I'm adding to that. Again, it is a Fifth Amendment violation for one of the people to bring criminal charges against themselves. They cannot be brought against themselves. As I am one of the people of the state of Colorado, and there is no accuser, there is no action that anybody can take against me. A corporation cannot bring a matter against a living man or woman. I am a living, breathing, live flesh and blood man. The state cannot bring charges under corporate law, under admiralty law, which this court is presumed to be operating under, which is contract law, cannot bring charges from a corporation to a man. It must be a man versus a man, or a man versus a woman, etc. If anything other than that is a dishonor of the court and a violation of common law, which the Supremacy Clause of the Constitution of the United States for America specifically states that common law is the law of the land. And I've already made it established in this court hearing today that I want to face my accuser, which is my right under the Sixth Amendment. And I waive no right at no time in no place.
I understand that's your position. Court notes for the record, this is not an admiralty court. There would be no admiralty jurisdiction except under the navigable waters and adjacent territorial waters of the United States, which does not include Breckenridge, even back in the 19th century when it was the Kingdom of Breckenridge. I again will address this quo warranto. It appears you filed this twice. I have the same document, the same title, filed both September 20th and September 23rd. So, do you have anything you want to add to either of those two pleadings?
No, we can go through those line by line. As I stated that all of these motions and affidavits and notices to the courts have not been properly rebutted by the town attorney who is operating under a fraud without a valid signed oath of office pursuant to Colorado state
Right,
law.
We've covered that. You made your position in the prior motion. Both of these filings reiterate the oral position of the defendant that he's a natural, living flesh and blood man, distinguishing that from being a person under the Constitution which there is not a recognized version of, that it looks like there's a request for quo warranto that is for an order to compel a public official to complete their duties, but.
Can I ask a question, Your Honor?
In a minute. But not a citation of authority of this court to issue a writ of quo warranto. You may have your minute. What is it, sir?
So is this court going by definition under Black's Law, Bouvier's Law, or Ballantyne's Law Dictionary, or are we operating under the proper English Oxford Dictionary?
No, we're not operating under dictionaries. We're operating under case law and the Constitution of the United States, which defines person as those persons born within the United States. Mr. Gregory, did you have anything you wish to supplement to the record as far as the quo warranto motion?
I guess just to reiterate some of the positions that the people have already stated in the response to the notice to the court, just generally with respect to this writ of quo warranto, municipal courts have no authority to issue remedial writs. So first of all, the request being made to this court can't be granted by this court. Second of all, writs have been abolished in Colorado under Rule 106 of the Colorado Rules of Civil Procedure. So in this case, the request that Mr. Anderson is seeking would be under Rule 106, and that needs to be filed in the district court. I would state for the record, it's my understanding Mr. Anderson has filed a Rule 106 motion in the district court here in Southern County with respect to a FOIA request that he made that has ultimately been dismissed.
I'm sorry, I object to that. I have not.
Hang on, these one person at a time.
But with respect to this particular case, there's no final judgment in this case. Mr. Anderson hasn't even provided this court with a not guilty plea or guilty plea, so no pleas have been entered in this matter. So there's no final judgment upon which a writ can even be granted in this case. With respect to that request, it's both improper and not right. With respect to the due process request essentially that the defendant was making in this notice to the court, the people would respond that I respect every defendant's due process rights. I want every defendant to get their due process rights, but I would state for the record, Colorado Constitution in Article 2, Section 16 provides that criminal prosecutions, defendants have certain enumerated rights. Those are the right to appear and defend in person and by counsel, the right to demand the nature and cause of the accusation, the right to meet the witnesses against him face to face, the right to have process to compel the attendance of witnesses on his behalf, and a speedy public trial by an impartial jury of the county or district in which the offense is alleged to have been committed. In this case, that would be within the town of Breckenridge. I certainly encourage the court to ensure that the defendant has those due process rights. To the extent the defendant's asking for rights that aren't enumerated in the Colorado Constitution or within the town of Breckenridge, we do not consent to the court providing those rights. For instance, the defendant is demanding that he has a right to consent to his own criminal jurisdiction or to his own criminal prosecution, which there is no authority for that. Any authority the defendant has cited is irrelevant or inapplicable or only exists in his own head. With respect to those due process rights, he has been provided the due process rights he's granted so far in this case, but as I stated previously, the defendant has not entered a not guilty plea, so the rights associated with the trial have not been, they're not ripe yet. Certainly, if and when we get to a point where the defendant enters a plea in this case and to schedule a trial, he will certainly have those due process rights associated with the trial.
So in response to that, Your Honor, the Constitution and all the rights therein are at all times. This does not pertain to just when it goes to trial or after a pleading. I don't waive any rights that are also not noted by the town attorney. I maintain all of my rights at all times. So again, to caveat with what the town attorney himself just stated, that I have the right to face my accusers, in which that would mean in this hearing here and today that I have the right to face my accusers, in which they have not brought forth any accuser in this matter except for Robert Gregory over here, the town attorney, in which he stated during the last hearing that he was the injured party in the matter so that he could represent the people of the state of Colorado, therefore effectively committing fraud. Secondly, on the motion that he referred to that was sent to the district court, that was sent to the district court either by your counterpart, Judge Buck Allen, or the attorney himself. I never filed anything with the district court for Summit County. I did receive a letter or a statement in the mail stating that they have filed something within that court that was an order to dismiss. However, I did not bring any motion there, so he just committed perjury and fraud on the record in stating that I had filed something when I did not file anything with the district court. The matter that was filed with the district court was that they filed, not that I filed, was a motion to compel a lower court, had nothing to do with a writ of quorinto. So whatever he's stating is false, and I would like the court to take judicial notice of his stature in this matter, as he is, again, not a valid individual in which he can or cannot represent the state of Colorado, as he has no valid oath to the people of the state.
Okay, understand your position. I am curious, in paragraph 10 of your September 23rd filing, you make reference to a 4D agency and garnishment, and 4D agencies are child support. Are you claiming this matter somehow involves child support and a 4D agency?
I believe that might have been with a part of another filing that I had filed with another court for a different matter.
Okay.
If that's the only difference between the two, it has to do with Title 4D, then that would be something that I had filed with another court.
Well, the first page of these two documents, as I noted, the two different filing dates are the same. The second page is generally the same. The third page is generally the same, but then we get to the back part of the fourth page. Well, no, both of them refer to the 4D agency. One is in paragraph 8I, and one is in paragraph 9 and 10, which just sort of puzzled me. Having prior experience when I was in the Attorney General's office with 4D agencies, I did not see the connection, and you clarified that it may be an editing issue.
It only with reference to anything that might do with child support or 4D or wage garnishments. That would be the only thing that I would.
There is no ordinance claim for wage claim or garnishment. That's not a possible punishment in the municipal court, so I'm going to ignore that part of your filings. All right. Court having heard the arguments of the parties, the court does note that municipal courts have no authority to issue remedial writs under City of Inglewood versus Parkinson, 703 Pacific 2nd, 626, a Colorado appeals case from 1985. And Rule 106 of the Civil Rules of Procedure indicates the court that Colorado has abolished special writs. Defendant does not cite any authority indicating this court or any court in Colorado has the authority to issue these writs. And the court finds it's without jurisdiction and authority to issue a writ of quo warranto, so I would deny the motion for quo warranto. All right. court, having reviewed the file, in case there's no number of other filings that are not in the nature of motions set for today, Mr. Anderson, do you believe there are other motions that are set?
Yes, can you please list off the titles of each one?
Okay, what I've got for the 4 motions.
No, I'm sorry, Your Honor, for the ones that you just scrolled through, because there's other filings that were with this court and you have not addressed the rescission. The court has also not addressed the notice to the court, which is on the record for the state of Colorado, showing that I am not a corporation, and it also shows my fee schedule, in which any order or anything from the court or from the prosecuting town attorney will be charged and billed under a true bill for. So we need to address those as well, because those are a part of this hearing. Those are a part of what I've been stating on record, that I am not a corporate fiction in which this court has alleged I am a living man.
All right, well, let's go, I'm gonna just go through the whole file, so that we have, I have a document that's entitled Cover Sheet, Town of Breckenridge Municipal Court to alter, ignore, or dispose of as a felony mandatory notice, Foreign Sovereign Immunities Act, Section 1605 and 1607, notice of liability, 18 U.S.C. 2333 and 18 U.S.C. 1341 and U.S. 1342. And the title continues farther as to, for record in case 69901, court administrator make record of case and released to attorney Bob Gregory, number 42560, 1, certified affidavit of non-corporate existence, 2, certified affidavit of power of attorney in fact, 3, certified claim of damage fee schedule. Is that what you're referring to?
That would be one of the documents in which I'm referring to. That would be the initial one that you read off. These are all affidavits for and on the record.
Okay.
That
well, the first document is an affidavit of non-corporate existence. Court has read this document with its quote from Hale versus Henkel, that an individual may stand upon his constitutional rights as a citizen. And it goes on to indicate some matters concerning Federal Reserve notes and bank accounts. Is there anything you want to add to that?
that affidavit has been filed for the record within this case to prove that the corporate fraud in which this court is alleging under the name in which was announced at the beginning of this hearing today, which I am here under special appearance for, that one proves that this court is attempting to bring a living man into a corporation by trying to attempt to get a living person to contract, or a living man, I'm sorry, not person, because I'm not a person as defined by any dictionary, nor am I a person as defined by the 14th Amendment of the United States Constitution. That document was not properly rebutted by the state or by Mr. Gregory or by this court within 21 days. It's also on record with both Jefferson County for the state of Colorado. It's on record with the Secretary of State's office for the state of Colorado. It's also on record for Summit County, which I believe you have the copy that certified from the county. And it's also on record with the United States State Department, which all entities are required by law within 21 days to rebut. Anything that's not rebutted within 21 days stands as fact and truth in commerce, which this is a commercial court. So
I see no authority for the 21-day rebuttal, but affidavits are not a pleading that requires rebuttal. The court does note that apparently this was recorded with the Summit County Clerk and Recorder at reception number 1305086 on February 6th of this year. And does note that that was recorded. I don't know what it was recorded on or against, but it was recorded. Court notes your affidavit for the record, to the extent, and then it appears, is this the same thing? No, this is the total of 9. Appears the next affidavit is affidavit of truth, regarding administrative and maritime claims. Do you need to make some further comment or statement about that document?
That anything that the court or Mr. Gregory that is under fraudulent representation of the people would like to rebut must be done line by line, and if not, then those stand as fact and truth and commerce in this court.
They do not, but court has already noted the court has no maritime jurisdiction. I guess this claim of damages transgression fee schedule is part of that same document. That's all part of that affidavit of truth, correct?
No, that is a separate document.
That's a separate document.
It was filed, it was recorded together with the clerk and recorder's office, but they are two separate documents. One is the affidavit of truth, and the second one for that one would be the charges in which this court and Mr. Gregory will be charged and billed in a true bill statement for any matter that goes beyond, to include today.
Okay, well, it's a claim of damage, and I see it was put together because you recorded them together. I think as far as the public record, you have made them one document by recording them together. Then you have an affidavit of adverse claim. And this is, refers to Judge Buck Allen and Mr. Gregory. Is there anything you wish to add to this affidavit?
That affidavit now includes yourself, Your Honor, Judge Ronald William Carlson, attorney registration number 19145, as you are now the trustee that was appointed to this trust and this case number being 69901. So that one also would include yourself, sir.
I don't recognize that. I'm appointed by Town Council of Breckenridge, not appointed to be judge in no other office. All right, that's what's in the file. What else we have here? We have a cease and desist notice. We have something filed in the 5th Judicial District, so it really would not be part of this record. It's a motion to compel a lower judicial body to perform. I believe this may be what you and Mr. Gregory were referring to as being filed about a Freedom of Information Act request in the District Court of the 5th Judicial District.
That one wasn't filed. I'm not sure why that's even in the case for this one. I did not file that with, again, I didn't file it with the district court, nor did I file it into this case. Those were served through the registered mail to Judge Buck Allen and to the alleged town attorney, Robert Gregory.
Just noted receipt October 24.
I'll just state for the record, it had to have been filed by you. The court has a case number 2023 CB 030019. Plaintiff Christopher Anderson, defendant, town of Breckenridge. This is a Rule 106 action, so I just want to state for the record that I can't support action.
Okay. The court has that in the file. I don't see where that requires any action on part of this court. What else did you think needed to be gone through here, sir?
The rescission.
Okay, court finds after all of that material, there is a notice of rescission. Make some reference to Marbury versus Madison. Says it denies responsible for errors and omissions of officers, agents of Christopher Lee Anderson and any instrument in the United States. Anything you wanted to add about that? I've already ruled that contract principles don't apply to jurisdiction of the court, so far as this notice of rescission, I find it to be not applicable to the jurisdictional issues of this court.
I'm sorry, the constitutional law references and all case law that is within it does pertain to this court, and this court is mandated by the Constitution and the oath in which you took to the United States of America's Constitution, that all matters must and shall be recognized by every court.
Okay, I understand your statement. That appears to conclude what I have for the file. Do you have other matters you believe that need to be addressed today?
Everything will be addressed in a higher court after this hearing when I get the official record and transcripts from this hearing, since the court is choosing not to adhere to their appointed trustee dutyship under their fiduciary responsibilities within this matter.
All right, you indicated you thought I did things out of sequence. Court will revisit the motion to dismiss with prejudice. Is there something you'd like to add at this point?
Yeah, I do not consent to any rehearing. I don't accept the court's offer for that. The only thing that I will allow the court as the living man to do today is to collapse this CQV trust and dissolve and discharge this constructive trust that's been created. Anything beyond doing what your titled duty as a judge is for as a federal notary is a dishonor to the court and a violation of your oath, and anything more than dismissing and dissolving the charge in which I have only granted this court the ability to dissolve and discharge the matter to me is a dishonor to your oath and to the Constitution of the United States of America and to the people thereof.
All right, court does not recognize the trust you allege to create. The court only recognizes that you are physically here. You are an individual defendant over this court, and this court has jurisdiction over both subject matter and personal jurisdiction is the ruling of this court.
Question for the court.
I'm getting my ruling, so you can wait.
I do not accept or consent to your ruling.
I understand that, but you get to listen to it. Response in terms of court order, motions the court addressed were the motion to demand the court read all pleadings, and court did read all pleadings, and court is applying the rule of law pursuant to the Constitution of the United States, laws of the state of Colorado, and the ordinances of the town of Breckenridge. The motion the court also ruled on was for the issuance of a quo warranto writ, and the court has denied that for the court lacking authority to have that writ issue, or that there's any writs of that nature in Colorado at this time. And then the court has ruled to deny the motion to dismiss with prejudice for the reasons stated on the record in detail. This court has both personal jurisdiction and subject matter jurisdiction over this defendant. And those were the motions that were set. Mr. Gregory, any other motions?
There are no other motions that I believe were pending before the court. There is one more thing I would like to add, but the court has disposed of those.
Sure.
Motions.
And what's that?
People would like to just state for the record that under Rule 211 of the Colorado Municipal Rules of Procedure related to pleas, in Rule 211, subsection D, it states that if a defendant refuses to plead, or if the court refuses to accept a plea of guilty or plea of no contendere, or if a corporation fails to appear, the court shall enter a plea of not guilty. So-
Before you go any farther, you just said a corporation. Can you please clarify the corporation? Well, I don't want to get lost, Your Honor, so I just wanted to clarify what a corporation is.
I'm not gonna respond to your question. The people are just stating for the record that, we would request that the court actually enter a plea of not guilty so we can get this case scheduled for a trial, since there are no further pending motions. The court can certainly enter today, or if the court needs to consider that request, or, schedule this for another date. People have no objection to that, but.
I have an objection to scheduling it.
I would ask that the court enter a not guilty plea since Mr. Anderson has refused to enter a plea thus far.
All right, now, Mr. Anderson.
I object to everything that the alleged town attorney just stated as A, he has no valid oath of office and cannot actually perform anything. Everything that he just stated is void on its face. Secondly, I do not consent or accept any offer of the court. And third, I would like clarification as to if this court knows what general appearance and special appearance are.
The court doesn't recognize special appearance in criminal cases.
Okay, so there's no such thing as special appearance
There
for
is
a
such a
court.
thing as special appearance.
Okay, so the prosecuting town attorney just stated under civil procedure, the rule that he just clarified, not under criminal procedure.
No, he
Um,
had
so-
cited the Colorado Municipal Court rules is what he cited.
For civil procedure, not for
No,
criminal
no.
procedure.
211 is for municipal court procedure.
Okay, I do not recognize or accept or consent to that as, to be able to consent to any municipal law or anything statutory municipal or ordinance or code or regulation or rule, I must be an employee thereof, and I am not an employee, I am not a corporation. Again, I am here under special appearance as a man, a living man, in which a corporation cannot be injured by a man, and a man cannot be charged or alleged charged by a corporation. So I would like to get that known and made for the record. It doesn't matter whether or not the court agrees with that or if they understand that. I do not understand the allegations in which were brought against me or which are alleged against me, a living man, because, again, Sixth Amendment per the Constitution of the United States of America, I have not seen my accuser. There is no accuser. Who brings this matter before a living man? That's what I would like to know, is who is bringing this matter against a living man? Who is the injured party? There must be an injured party for a crime to exist. If there's not an injured party, or a man or woman, then there cannot be a crime. So I would like to know, for and on the record, who brings this matter, who brings this forward. And since the court doesn't recognize that they are the appointed trustee and the appointed, self-appointed executor of this trust, which I am the beneficiary of, and the secured party, I would like to know who brings this matter. That's what I would like to know. The people of the state of Colorado cannot bring the matter because the people cannot be injured because I am one of the people. I cannot bring this matter against myself. There's witnesses within this courtroom who also did not bring this matter, and I would surmise to say and guess to say that if the court asked for their voice or their opinion, as them being one of the people, that they would also not consent to this matter either, as I did not injure or harm all of the people of the state of Colorado. So for clarification on the record, I would like to know who brings this matter before this court. And I would like, okay, so I would like to see the town of Breckenridge. I would like to see who that person is.
You'll have a right to confront the witnesses against you at the trial.
Now, I have the right, per the Sixth Amendment, to face them now, here, in this hearing today. Every hearing. I do not waive any of my rights.
You are mistaken.
You are mistaken.
Hang on, one is the way court procedure works is you don't get to argue with each other directly. You may state positions to the court, but you don't get to argue with each other directly.
Yes, sir.
You've made your statement, and I understand your position, that you your position is that your accusers should have to be at every court hearing. That has been previously ruled on. It's not part of the rules of procedure. That right to confrontation occurs at trial.
So where does
You also could have subpoenaed anyone you wanted for today's hearing, and you chose not to do so. So, as to the accusations, you are charged by the town of Breckenridge with, one is disorderly conduct. That ordinance states, disorderly conduct designated is unlawful to commit disorderly conduct. A person commits disorderly conduct if he intentionally, knowingly, or recklessly, one, threatens physical harm to any person in a public place, or two, makes, causes, or controls unreasonable noise in a public place, or that is audible upon a private premise that he has no right to occupy, or three, fights with another in a public place, except in an amateur or professional contest of athletic skill, or four, makes comments or gestures calculated to cause embarrassment or provoke anger in any person, intends to invite an immediate breach of the peace, or five, urinates or defecates upon any public or private place other than in a toilet facility provided for such purpose. That is what you are charged with. Section B, evidence, a prima facie showing that a violation of subsection 2A of this section shall consist of evidence that the defendant caused or controlled such noise between the hours of 10 o'clock p.m. and 7 o'clock a.m. that was audible at a distance of 100 feet from its source, distinguishable from any other source or sound in the vicinity, and was of a greater volume than any other single source or sound in the vicinity. So that is the first charge that you are charged with. Then you are charged with assault, which I will get to here. Section 6-3A1, assault. A person commits the municipal offense of assault if the person knowingly or recklessly causes bodily injury to another person, or with criminal negligence, the person causes bodily injury to another person by means of a deadly weapon. So that is assault. And then the third charge that you have is open containers, which is section 6-3F16. It is unlawful for any person to possess any alcoholic beverage in any open container, or to consume any alcoholic beverage in any public place within the town, or in the interior of any motor vehicle while the motor vehicle is either parked on a public street, right of way, or alley within the town, or is being operated on a public street, right of way, or alley within the town. 2, the provisions of section A1 shall not apply to the possession of an open container or consumption of an alcoholic beverage within the licensed premises of an establishment licensed by the town to sell such beverage for consumption on the premises, or to the possession of an open container or the consumption of any fermented malted beverage, malted liquor, or Venus liquor is defined in the Colorado Liquor Code in those public parks known as Kingdom Park or Carter Park. 3, the provisions of subsection A1 of this section shall not apply to a person in possession of one open but resealed container of partially consumed Venus liquor, which was lawfully removed from the licensed premise of an established holding a liquor license pursuant to this section. And then section 4, the provisions shall not apply within a permitted area of a special event. So that's what the 3 charges are that you are charged with by the town of Breckenridge.
Okay, so again, I have the right to see my accuser. If my accuser be here today, please step forward. The living man that I assaulted, the living man by the name of Town of Breckenridge, I would like to see them so that I can hear this, because I bring verified, my claims are verified, my claims are fact. However, I bring remedy to all verified claims of the person known as the Town of Breckenridge. So we can remedy this here and today if I can face my accuser. So that's what I would like the court to bring forth my accuser today, here and now, so that I can bring forth remedy to their verified facts, so that they can attest that that actually happened here today. So that person, if they're in this courtroom, can they please come forward? Can you please call that individual forward so that they can verify the claims against, allegedly against the trust in which you guys have charged? And secondly, before the court decides whether or not they're going to enter a plea on behalf of a living man, that would constitute as practicing law from behind the bench. And so any statute or code or ordinance or regulation that the town attorney, which doesn't have a valid oath, stated is invalid. So that would be impractical, and it would be a violation of practicing law, as again, you cannot make or enter a plea on behalf of somebody from behind the bench. That would make you practicing law from behind the bench. I understand that both of you have attorney regulation numbers, meaning that you both work for the same corporation and you both stand to make a profit off of this case within that corporation for practicing law. But again, I bring remedy to all verified claims for that living individual known as the Town of Breckenridge, who actually brought forth these claims against me, the living man. So that would, what I would like the court to do is to show me the accuser, please, here and today, so that way we can remedy this, and we don't have to drag this out into some long drawn out trial in which all of this is going to end up happening again. Because you're going to have to prove in trial who that person by the name of Town of Breckenridge is that allegedly charged me with the living man with these crimes. Because again, in order for a crime to exist, there has to be an injured party. The city, the state, the town, they cannot be an injured party. I have the DUNS number proving that the Town of Breckenridge is a corporation and not a person. I didn't bring the DUNS number today because I didn't assume or presume that this court would entertain these charades as long as they have. So for the next hearing, if that's what the court is planning on doing, I will bring in the DUNS number for the Town of Breckenridge, for the Summit County, and for the state of Colorado, which effectively would make sure that everybody is aware that is a corporation against a living man, which cannot do. So
Okay,
that's what I would like to
yourself,
know.
sir.
Yes, who brings the
You're
claim?
repeating yourself over and over. Enough. You've requested the injured party be here today. I've already ruled that this is a motions hearing. No one else needs to be here. If you wanted someone else here, you could have subpoenaed them. You didn't do that. The court has ruled on the motions that were pending before it. Court notes attorney registration numbers are with the Colorado Supreme Court, a constitutional body under the Constitution of the state of Colorado, and also one of the 3 branches of government of the state of Colorado as recognized by the U.S. Constitution when Colorado was admitted as a state. Court does not recognize any trust. Court recognizes your physical person is in front of the court today. Court has ruled it has personal and subject matter jurisdiction in this matter. and I understand you object to any plea being entered on your behalf. The court takes that that objection is the refusal to enter a plea, and the court therefore enters a plea of not guilty on your behalf.
I didn't refuse, I'm just not going to enter one because I do not consent to the matter before the court, and I do not accept your offer either.
I understand. But the court's gonna enter a plea of not guilty.
I object and I do
We
not
wanna set
consent
this for trial.
or accept your
at
offer.
which Next court session. Mr. Gregory, how much time do you need? Or
Well,
where do you wanna set this?
I think it depends on if Mr. Anderson is requesting a trial by jury. If so, sufficient time to actually.
Mr. Anderson, you requesting a trial by jury?
I waive no right at no time, so that means that per my Sixth Amendment right, that's a requirement.
I mean, the issue is juries are to be done by a written demand within 20 days. I will set this for a pretrial again at the next session of court to see whether a written demand for jury trial has been received. And then we will call that pretrial a trial setting.
And what law states?
For what date that would be.
What law states that it must be in written demand? Because I'm not waiving any right pursuant to the Constitution.
Colorado Rules of Criminal Procedure.
Okay, that doesn't supersede the Constitution, so therefore by the Constitution, I waive no right, and this court is bound to uphold its oath. Therefore, it will be a trial by jury, a jury of my peers.
Well, that sounds like, demand for a jury trial, but I think we have to set this for a jury trial.
Since the court is practicing law from behind the bench and entering a plea on behalf of a living man against a corporation, I demand all of my rights at all times and in all places. I waive no right at no time and in no place.
And I think I saw a document here that had the court dates. Except, we would want this,
The court typically schedules jury trials for, rather than the Wednesdays that we typically have court, on Fridays, I believe is.
Okay.
Judge Allen's
Um,
approach. I'd probably be looking at the May dates.
and this calendar they provide me doesn't go as far as May. It's through April.
But as the second and fourth Wednesdays of every month are court dates. And typically with jury trials, we schedule it for the Friday of the week that we do have court. But,
Well,
I suppose if
then I would be
if you're-
concerned, I guess I'd be concerned about speedy trial within 90 days is the next issue.
I won't be here for the next 90 days, so, but I don't waive my right to speedy. Because I don't accept or consent to the offer of the court.
I understand. April 28th.
That works for my schedule.
All right. Sir, you are advised that a trial will be held April 28th at 9 a.m. You are ordered to appear at that time. If you fail to appear, a warrant for your arrest will issue.
I do not accept your offer.
I understand you make those statements. What address, do you have an address on file with the court?
The court has the address that it's been sending documents to.
Okay. And have you received documents at that address? What address are you using?
It's a post office box that the court has on file. It's also within every one of my motions and affidavits.
Okay, this is the,
That would be the correct mailing address.
okay. Court mail a notice of trial to that address. All right, that concludes the matter for today.
I just want to make it on record that I do not consent to anything that was stated here today, and I do not accept any of this court's offers.
I understand you're making that
I'm glad that it's understood.
And you understand that I've ordered you to be here on that date, or a warrant will issue for your arrest for non-appearance.
No, I do not understand or stand under the court's order.
But you understand English?
No, I do not understand
What
this
language
court's
do you
order.
speak? What language do you speak, sir?
I'm invoking all of my rights.
All right, that'll conclude the matter for today.